Hello. In this recording of our Justia webinar, 10 Commandments of Appellate Brief Writing for Associates, Marina Wilson explores 10 suggestions that will help you write strong appellate briefs so that you'll be confident handing it off to a partner for review and ultimately to court for your client. Remember, if you'd like to see more Justia videos on law practice and legal marketing, be sure to subscribe to our channel.
Hey everybody, thank y'all for having me with you today. It is an honor to be back here with all my friends at Justia and to see so many new and returning faces. With that being said, I'm here today to talk to you about appellate brief writing. So in my practice, I spend a lot of time researching and writing. We have a couple of different, we're a small firm, but we have a couple different roles and responsibilities. And so we all help with some of those things, but the bulk of my time is spent researching, writing, and looking into legal issues. And so with that, that's an area that I enjoy a lot. And so I've done a lot of work in it myself. I am not saying that I know all of the great answers to those things. I am saying that I have learned some things along the way from a lot of great lawyers and am hoping to impart some of that wisdom to you. But remember, I think an overarching theme to all of this is, as you know, I don't practice in many of your jurisdictions. I'm based out of Louisiana. So to the extent that I talk to you about anything law, please remember it's not legal advice. This is not ethical advice for your area. By all means, work on your own professional responsibilities and your own professional duties. And then the other thing is knowing your audience and knowing your style. So you might get to the end of today's presentation and say, I hated all of that. My feelings won't be hurt. That's fine. But hopefully there is something here that you can learn today to help you along the way. Let me see if I can get the slides to move from you. There we go. So like I said, I launched into those disclaimers. This is not legal advice in any jurisdiction. I'm also in no way telling you how to practice law, and something else might work for you. This is often a personal process to figure out what your own style, your own voice, and your own effective methods are. But diving straight into those commandments, those 10 things that if I was going to give out 10 commandments from on high for appellate brief writing, the first one that I would say is thou shalt know your local rules. I don't know how many of you remember this day as a baby lawyer or a brand new associate when you discovered that there were local rules. I did not come out of law school knowing that. I thought I had a handle on research. I thought I had a handle on writing. And then I went into a law firm and I learned about a Rule 10.1 conference, which in Louisiana is a uniform district court rule for discovery disputes, actually. Before you file a motion to compel, you have to have a 10.1 conference with the other lawyers. The problem is that I had no clue that that existed. And I also had no clue that there were local rules that set those things out. The good news is once I, got into practice and learned that those did exist and spent some more time in them, it's very interesting to see that those local rules cover what you need to know in a variety of areas. And so it can help you understand all kinds of things, either your local rules, which we have. We also have statutes here, obviously. In some states, they're a little bit more statute heavy for what you need to know for your appellate brief writing experience. Again, I defer to your knowledge of your own practice area, your own practice jurisdiction for that. But they will tell you all kinds of things. First and foremost, the timeline for filing your briefs. Nobody wants to file anything late. We all know that lawyers like deadlines, especially when you're in things like federal court. It's very strict often. In state court, at least here, there might be some more wiggle room, but the judge does have that final say. And you want to make sure you're requesting extensions if you need them. And especially at the appellate level, you want to make sure that your deadlines are calendared and you've got things on the up and up so that you don't miss something and forgo your client's rights. The other thing that these local rules or statutes might tell you is what you need to include in your brief. So when you sit down, I like to make a checklist every time I write one of these briefs of all of the parts that need to be in it. So everything from whether or not you need a statement of the case, whether or not you need a statement of the issues, how you format those things, how you present those things, what kind of summary of your argument you need. In addition to the meat of your argument, all of those things are going to be spelled out there for you somewhere. So by knowing your rules and checking those things out, you can make sure that you've kind of dotted your I's, crossed all your T's, and you don't have any problems. It sounds like a very elementary thing, but you don't want to get hung up on something technical. You don't want the court to reject your brief for some reason. And so you really want to make sure that you've kind of gathered that low-hanging fruit to kind of set your best foot forward when those judges start reading what you've presented. The other thing is formatting, right? So we can argue and people can debate all day if you need one period or two periods. One space or two spaces after the period. I personally am a one space girl, but I know a lot of people will say that's an issue. But courts care about formatting too. They care about margins. They care about paper size. They care about font sizes. They care about spacing. And no matter what your opinion might be about whether Arial or Times New Roman is the best font, or whether or not you like things single spaced or double spaced, or whether or not you want your citations in line or in footnotes, all of the courts typically have a way that they prefer to have that done. And so by knowing those local rules and looking into those statutory requirements, depending on where you're at, you can know that you've crossed all of those T's and dotted all of those I's as well, so that the judges don't have any reason to be put off by your product when they look at it. So here's an example from my good old Louisiana rules. And I also included some more rules for you in those written materials. You can read, I'm not going to read this to you, but that touches on some of the things that we have, right? Your brief has to be in Times New Roman. It has to be at least size 14 font. You have, if you're still using a typewriter, rules about what's included in your spacing for a typewriter. The margins, if you can use a footnote, that's all included here. The size of your paper, also included here. Page limits, so you don't want to write something that you think is amazing and goes well beyond your page limits, because some judges will just stop reading, and some lawyers will say that the court has to disregard everything that you've submitted beyond that limit. So you want to make sure that you're kind of putting your best foot forward and putting your best arguments forward so that you can make sure your client's rights are protected, your interests are protected, and you've done all of that within those easy, like I said, limits that are low-hanging fruit. So how are we keeping track of it all? Calendar. The calendar is important. I know that sounds incredibly elementary, incredibly basic. But for me, I am often one who says, yeah, I'll stick that on there. And then you forget, right? You have something else going on. If you don't do it right there, somebody called you, an email came in, or your personal life intervened. You know, you were at home when you saw the email, or you were at home when you calculated the deadline, and here comes your dog or here comes your child, and they take your attention away from that thing that you were working on for a moment. Well, then, you might not have made it onto your calendar. So you have to make sure that you have that practice and making sure you've got your deadlines for everything on your calendar. And also, I would suggest a firm-wide calendar. If you don't practice alone, then we maintain a firm calendar where we can all see, firm deadlines, the filing deadline for a brief, the filing deadline for an answer, the deadline for a discovery date, but also our personal calendars. And so for me, if that's a firm deadline, that's something I have to, manage, it makes it to my personal calendar. I'm a pen and paper girly. I say I don't know how to practice law without a physical calendar. And so with that in mind, one of the first things I did when I resumed my practice is I went to Target and I bought a planner. And I shortly realized that a 1-year planner wasn't enough for me. And now I am the proud owner of a 3-year physical calendar. I carry it everywhere. I joke that I live and die by it, but I write in it. And I write down my personal things. I write down hearing dates. I write down deadlines. If it's something that I need to know, it needs to be in that calendar. And that's a practice that I've had to be disciplined to maintain. I also mentioned your checklist. And so make that checklist like I talked about, so you can make sure you've covered all of your bases. You can write out the required portions of your brief so that you can check them off. The last thing I do before I file anything is I pull everything together and I do manually look. I have the cover page that's requested of me. Check. I have the statement of the facts. Check. So on and so forth. And then those formatting requirements. If any of you are, a little bit type A or a little bit anxious, then you're probably already double checking. Did I make sure that the margins were 1 inch? Did I make sure that the size was a 14 font? But if you're not, then add that to your checklist too, and make sure that you go through and check those things one last time so that everything looks nice and complies with the rules that have been presented to you. Moving on from that, number 2 is thou shalt outline. And I say this seriously. I don't know about you, but I will also confess again that I am someone who used to sit down and just start writing. I thought that I didn't need to outline. I came through school that way, all the way from elementary school, going up into law school. I would just write and it would turn out okay. And sometimes I would proofread and sometimes I wouldn't. Again, a problem. And I learned along the way that my work product seriously improved when I did those basic things that my teachers had told me to do all along. So now I outline everything. I start with my argument, and it might not be pretty. It might not be on a computer. I often will sit down with a notepad. Sometimes I'll do it with a note on my phone so that if I have a great idea, wherever I am, I can add to it. But outline your arguments. And that's where I always start, is my argument. What are the main contentions that I want to prove or I want to show to the court in this? What is it that my client wants to make sure that this appellate court knows? Why was the lower court wrong? Why should this be reversed? Or if I'm on the flip side of things, why they were correct and why they need to defer to what the lower court already decided. And once I have that on paper, you can fill in those blanks so that you kind of know how your argument's going to look. So for instance, something that started out as more general research, right? Like I grabbed sound bites off of Westlaw or Lexis or whatever research tool you're using, and paste those along the way so that I know this is the case I want to go to. This is the proposition that I wanted to cite that case for. And that way I don't forget anything along the way. And once I get into the meat of the writing process, that's something that is very helpful to already have set out for me before things even started. You want to make sure, too, that you've covered other bases. So are you arguing in the alternative? If you have your primary argument and you think that's your winner, great, lead with it. But as I'm sure many of you know, there are often alternate bases that would still get your client the result that you're looking for that are well-founded and you want to maintain for the court. So here, we often will argue in the alternative. In the alternative, in the event that you disagree with my main argument, there was an error below because. And then outline that argument too. You want to make sure that you've outlined the essential elements of that argument. You don't want to miss an element of negligence if that's something that's important to your argument. You don't want to miss the standard of review if that's something that's going to help set forth why the court should agree with your position at this next phase of litigation. And then your facts, right? You're going to need facts to support your argument in most cases, if not all. You're going to need facts that show what you're looking for to prove those elements, facts that show why you're correct and why you should get the relief you're seeking. And all of that should be in this outline form in some way, shape. Now, remember, you want to be thorough here. I can't say that enough, but you always want to consider what would be needed to persuade the court. You're not even writing yet, the full thing at least, but with that in mind, it's so much easier, I find, to scale back than it is to add on. So I'm someone that my practice is when I'm drafting or when I'm outlining, I will just let it keep growing. And then once I've gotten to the point where I've said everything that needs to be on this piece of paper I can cut back from there. Maybe I could phrase this differently. Maybe I could remove this argument. Maybe I could address that in another way. But that's much easier to do on the back end once you know your bases have been covered. Now, the next thing is storytelling, right? Thou shalt tell your client's story. The facts are your opportunity to make this interesting. Nobody sat, or many people did not sit in their first year contracts class or their first year procedure class and think that many of the cases were riveting, right? I mean, there were some that, always stick with you or that the facts really stay in your head. Anybody think about, the hairy hand? Because I will never forget that. But most of the time, it's not super interesting in many disputes. But judges read this stuff day in and day out, and they're inclined to do their job, but they're humans too. So if you can paint a picture for the court, you want to do that for them. You want it to be more interesting. This is your opportunity to tell your story. This is the point where you could humanize your client, right? None of us are perfect. And I think oftentimes the law assumes perfect actors, but everybody's kind of just doing the best that they can along the way. So when you're involved in something like a tort suit that you take it up on appeal, if your client is in the wrong, This is an opportunity to paint the human that they are. The flip side of this is that if your client is the plaintiff, you've got an opportunity to tell their story and how they've been wronged here, and they deserve some sort of recovery from the lower court that you want the appellate court to also go ahead and maintain or grant that the lower court did not. So this is your opportunity to set that stage and put some color into what otherwise might seem to be a little bit more technical or a nuanced argument based on the law. Don't get me wrong, sometimes there are things that are purely legal arguments. But for the most part, having whatever little bit of flair your facts can help give you that paint the full story, that's something that you want to include to the extent that you deem it's appropriate for your circumstance. What you don't want is the court to see this, right? You don't want something that's just black and white and boring and not a great argument. You want the court to see something that's engaging. So you want to include those basic facts, right? Those facts that are necessary to make sure you're telling that limited story. But you want to think about the bonus facts too, right? What are the additional facts that help set the scene? What is it that's not necessarily 100% integral to your argument, but gives a little bit more background to the court about why it is that you're here, or that helps the court better understand what your client's position was when everything was going on? Framing is everything, and it can make a major difference in how the court perceives your client and understands your case. So what you don't want to do, right, is you don't want to hide from bad facts. The facts are what they are. And sometimes we have facts that we wish did not exist. Sometimes you are looking at a scenario and you are like, geez, I don't know what to do with this. How do I help defend my client's interest in this circumstance? You don't want to hide from the bad facts. But what you can do is you can portray things with your words in the best light. And I'm not saying being dishonest to the court. Please do not think that. But for instance, people say the term weakness versus area of opportunity. In the end, they often mean the same thing. It's something where you can improve. It's something where you're not doing a great job, or you fell below whatever your standard that you set for yourself may be. But when you call something a weakness, it has a different connotation to it than saying it's an area of opportunity. So that's just something to keep in mind when you're setting the stage to ensure that you have told the story to the court that you need told for your client. So that'll bring us to something I mentioned in those initial setups that I said about the outline. You should know and you should state your standard of review. It can be a big deal about whether or not this is something that's subject to de novo review and the appellate court can decide from jump, versus manifest error or abuse of discretion, where there is some level of deference either to the facts that the district court has decided, or because the district court had discretion in the relief they originally granted, and so they should have some sort of deference afforded to them for that. So you need to know what that standard of review is and state it in your brief. And you want to highlight it, why it's applicable. And if the other party has misstated the applicable standard in their filing and you have the opportunity to respond, then you want to point that out respectfully, of course. But you want to say, no, this is not something that's subject to abuse of discretion. It's de novo review because, and cite the cases that stand for that proposition, right? What you can't do is just tell the court what you want things to be without any sort of support for that argument. So be sure that when you state the standard of review, you also cite to it. I think there are some things that we as attorneys who look at these things day in and day out might take for granted, or who we might kind of lean on and assume that we're all on the same page. But you can't do that. Every brief you write is new. Every brief you write is a new matter. And even when the judge already knows exactly what you're about to say to them, you still want to make sure you've said it and you've set forth that argument. Now, the next thing here is thou shalt not mislead the court. And I touched on this earlier when I was talking about framing your facts. But what you do not want to do is misstate or mischaracterize your facts, right? So while it's a fine line and you have to determine how in your style and in your, best practices, how to present your facts, you don't want to err on the side of misleading. You don't want to err on the side of misstating. I think everybody's had an instance where somebody pointed to a document or somebody pointed to a deposition or something, and they said in their filing or at a hearing or whatever circumstance it may be to the court, well, judge, the plaintiff said X. And you're sitting there and you're looking at it and you're thinking, no, they didn't say X, they said Y. You don't want to be in that scenario where it is as plain as day that that is not true, right? You want to be honest and forthcoming in what you're telling to the court and how you've presented it, while also making sure you're presenting it in the best light. The flip side of this is you also want to avoid erroneous statements of the law. So I know that we've all probably also had the experience where you see something in a case and there is a soundbite or a snippet that is just perfect. And then the court goes on 3 paragraphs later to say, never mind, that's not the law anymore. But despite that, it's different. For instance, I distinctly remember when I was learning in law school, right? When you do the history of the law and you learn about all those early cases, and so you're learning what tort law was in 1847. And then you get to 1902 and they're like, we've disregarded everything that happened already. That was a moment of like, oh no, well, why did I learn that? I think that happens in practice too in my cases, right? Like you'll have something you're researching, you'll have pulled the opinion on Justia, Westlaw, wherever you're getting your opinions from, and you'll be looking at it and you're like, yes, this is great. And then 10 paragraphs in, the court has said, now that we've given you all that background and now that we've presented all that argument, it doesn't apply, it's incorrect, it's overturned because. So you want to make sure that you're watching out for things like that. If you've got a proposition of law that is perfect for you, you don't want to stretch it too far, right? I personally attended a CLE about 2 weeks ago where they made the joke about an associate, right? That reads a case and you're like, this is perfect. And then you read the case and you're like, you know what? This is not the proposition of law that you told me this stands for, right? That case doesn't say what you said it says. And I can make associate jokes because I still am one. In those circumstances, it happens. What you want to do is avoid that in your appellate brief writing. The appellate court's law clerks, their staff, the judges themselves, they're going to check things. And you don't want them to read the case and say, well, that's not what that case says. Because then you end up with published opinions that are zingers talking about how you've misrepresented something, or you end up in a circumstance where you've undermined your whole argument, or you end up in a circumstance where your client is penalized because you did something like that. So be very mindful of those things. The other thing to keep in mind is updating your legal research. And I say yes every time. At a minimum, you need to be running all of your citations through whatever your legal research tool is every time to make sure that it is still good law. So I'm one, I will admit this, you've got something, you've had this case before, you've had this issue before. And you're like, I did a killer memo on that once upon a time. Let me use that as a starting point, right? The key word there is starting point. What you need to know is that you can use that to jump off on your research and to make sure you're headed down the right path. But what you don't want to have happen is your starting point is never double checked. Because the law does change. We all know it's a living and breathing thing. We all know that new opinions are handed down in jurisdictions across this country every single day. And sometimes the court overturns law. So there may be a case that you have been citing for 15 years that you say, that is it. That is the precedent. That matters. That is what I want for this case. And one day the court said, that case we decided it's no longer good law. Or the legislature came in and the legislature said, we've changed the law now. All those cases that were so well settled, suddenly they're no longer well settled. And so I had this come up recently in something that I was drafting where, there was a defense that in my practice is a defense that has been well settled for a long time. And so I started going into the drafting phase and I pulled, a case that stood for that proposition and realized that within the past year, the court had changed that analysis. So while the proposition was still there, it had to be looked at and discussed a different way than people have been discussing it for years at that point. And so you want to make sure that you're mindful of those things in the brief writing process so that when you give it to the appellate court, it's accurate and it is not an erroneous statement of law. You've captured that updated change in the way that the analysis now needs to be done for your client. So yes, every single time you should be double checking all of your cases, all of your research, as if it were a new issue to ensure that you've got things accurate. Which brings us to another statement, that thou shalt cite. So you want to do some things here in a couple of different ways. The first of which is familiarizing yourself with the record. And so when you've got an appellate brief, and this is something that is often unique to those appellate level cases, you're going to already be at the stage of your evidence is done. You're not putting in anything new. You've got the record that you are arguing about and arguing from before this court. And everything that you cite to is coming from, at least factually, or for where the court made misstatements or where the court erred, that record below. And so you'll get your record, and in some cases, they're much larger than others. And you'll have to go through and you'll need to refer the court to those lower court filings, whether it be the transcript from, the hearing where something happened that you object to, whether it be a filing that the other party had already made at the district court level. Those are all things that you're going to be citing to in your brief. And so those record cites are important for all of your contentions of fact, right? You want to be able to point to something in the record that supports the argument you're making, as well as the procedural history, right? Because by the time we're at the appellate brief writing stage, something has already happened in this case. Now, it may be a matter that was dispensed with early, and so you're in the appeals process early, in which case that procedural history is a little bit easier to, manage, though it still needs to be cited. But sometimes you've got cases that have gone all the way to trial, or they've had multiple appeals along the way, and they've reached a final judgment of some sort, and you've got a much larger record and a much more significant undertaking in locating in that record document what you need to cite to. So, for instance, I had one recently where the record was all on CD-ROMs. I had to go pick them up in person and get a CD reader and go through and, locate all of the facts and record citations that I wanted in that document. I had not used a CD in a really long time. I had to acquire, like I said, a CD reader to extract the files off of it. But I say that to say I needed it, right? Because even though that felt like a hassle and, that moment when I got the CD and said, what am I supposed to do with this? I don't even have a CD reader on my computer. I needed that information to be able to write an effective appellate brief. I had to be able to cite all of the facts that I needed to cite along the way. I needed to be able to support my procedural history. And so that is something that was important. With that in mind, remember, if you're litigating at that lower court level, your district courts, your trial courts, you're creating your record for appeal, right? And so something to keep in mind is if it's not going your way at the lower court, or if it doesn't go your way ultimately at the lower court, then you're going to want to make sure you've created your record for appeal. Because if it doesn't make it into that record, then at appeal, you're going to be stuck. The other thing here is you want to make sure you're including all your citations to cases and statutes. At this point, I think it's somewhat legendary in the legal profession. I'd heard the story multiple times. I talked about it here before at a Justia webinar. I heard about it in CLE last week. But the lawyer who asked ChatGPT to, give him citations for his brief, right? And that happened before, and he did it, and he sent it off to the court, and, the other side said, hold up, these cases don't exist. And so the court came back, and the court said, are these cases real? And he asked ChatGPT, and ChatGPT said yes. And then turns out, no, it had made up the whole thing, right? And this is not a presentation about AI. This is not a presentation about hallucination or how that happens or large language models or anything like that. The point I am making is that before the court, this lawyer needed cases and statutes to support his position, and he did not appropriately use the resources available to him to ensure that he had cited the cases as they needed to be cited, to make sure that they existed, to make sure that his argument was indeed supported by the law. So citations to your cases and statutes are important. You want them to be accurate. You want somebody to be able to drop that into Lexis, drop that online, be able to check and see, yes, this is that case, get it back, read it, and see if it stands for the proposition. See what else is out there on that point of law, right? I hate to say this because, it's not necessarily my favorite tool either, but use your Blue Book. They have citation standards for a reason. I am not going to say that I am a perfect Blue Booker, but it's there to help you along the way. I also like Westlaw to help me. You can, grab a quote and copy with the citation for whatever jurisdiction you're in. And at least you've got something to start with when double checking your citations. You should still reference back to the Blue Book for all of my, professors out there and people who are very good at citations. I know that Westlaw does not always get it correct, but that is a tool to help you get started on the cite track. The other thing is most legal research tools that at least I'm familiar with do have some sort of way for you to get started on that citation. If it doesn't, if the tool you're using doesn't have some sort of built-in copy with a cite, there are other free tools online where you can plug in your case information that you want to cite to, and it'll generate for you a Blue Book style citation. Again, technology doesn't always get it right, so you should double check that. But the tools are there to make your citing life a little bit easier when it comes to cases and statutes. And then remember, you want to update these cites and again, check them every time because you want to make sure that the case is still good law, that you've got the citation correct, that if you made a mistake in the cite, on page 3 of your brief, that you haven't carried that mistake forward into page 5, 6, 7, 8, 9, 10, or then into another brief that you use that case for because you thought you already had the citation handy, right? Your goal is to make sure that you've got everything as accurate as possible. Again, like I said before, we're all human, just like our clients. So you will find later, you'll find a typo in your citation. You will find a typo in your record cite. You'll find a typo in your brief. Don't beat yourself up about those things, but try to make sure that you've got them kind of situated on the front end. And so my best practice tip for that is the last thing I do before filing anything is double check all the cites, right? So I will go through when I've done that checklist, I've got, yes, I have all the pieces I need. Yes, this brief matches all those rules in pretty Times New Roman 14-point font. Excuse me, guys, I couldn't talk for a moment. And I will say, okay, now I'm going to check these cites. And I will copy paste into my Westlaw every single cite to the law and double check and make sure it pulls the case that I'm talking about or the statute that I've referenced. And that's actually what comes up in Westlaw when I put the cite in. With the record, I'll do the same thing. I will go through and I will check and I will say on record page 42, I said there was this quote. And I'll scroll through and find page 42 and compare. Yes, that is in both places so that I can ensure myself and my clients and my colleagues and the court that I have done everything that I humanly can to ensure that I have my citations correctly. Now, the next thing you want to make sure that you're doing is not engaging in personal attacks, right? Thou shalt not engage in personal attacks. I think that everyone can think of an opposing counsel that they don't necessarily get along with the best, or an argument that a counsel has made that they don't like, or a position for, whether it be their client or someone else that is not favorable. And litigation is inherently an adversarial process, right? So you've got here that element of the fact that you're at odds with a lot of people. And when you're in the practice of law, I think, many of you have already learned this lesson that you have to work, nicely together, essentially, that there's that element of professional courtesy. There's that element of, being cordial and having that professionalism with each other, that relationships in this business go a long way, right? That, you have to cut each other a break sometimes, whether it's an extension on discovery or an extension on an answer, or understanding that, something came up for opposing counsel and you need to move a hearing. Those same kinds of things apply in the appellate process too, to some extent, right? You might not like your opposing counsel. Maybe you guys had trial and they were just an absolute jerk to you and now you're at appeal. But you still have to deal with them in a professional manner. And the court is not necessarily going to take kindly to, personal attacks, right? So especially when litigation is contentious, but in every phase of this, right? Your key focus is avoiding personal attacks. You don't want to say that, the lawyer is not trustworthy, that the lawyer has lied, that the other party has lied. Those are very inflammatory terms, and that is not what you want to be telling the court. Your focus is on the argument and the facts and the law, right? So you can say their argument is incorrect. Their argument is not supported by the facts, right? But what you don't want to say is opposing counsel is dumb or opposing counsel made that up. And I think that everybody has probably read some sort of filing, brief writing, where somebody has artfully done that. You've also probably all seen in some circumstance where the court has kind of rebuked a lawyer or someone else involved in litigation for bad behavior, right? And sometimes I've seen it happen. The court will throw a reminder in there, right? Like counsel is reminded that. And that is just something that, you don't want coming at you, right? I joke that federal court is, great at public shaming. I say that with, good jest, but, if you file something in federal court, you get that PACER alert back and it says your pleading has been rejected, and they put it in the docket, they put it in the record, why you were rejected or what you did wrong. I joke and say federal court likes to shame me publicly. I think that the same thing goes true in the appellate process, right? What you don't want is you don't want to have a published opinion where you've been reprimanded by the court. That's the ultimate public shaming for the rest of forever. PACER would be small beans to that. So you want to make sure that you are engaged in professional, ethical conduct at every phase of the litigation. And that includes in the appellate brief writing process, right? You want to make sure that your focus is on the arguments and the law and on your client's position, not personally on any other party involved or their client. And that brings us to number 8, thou shalt edit and proofread. So with this 8th commandment, you want to make sure that you have given yourself time to edit your brief. I just said early on that I wasn't somebody who outlined, and that sometimes I would crank out a whole paper in school and then not edit it and not read it and just submit it. Your appellate briefs cannot be that way. Whether your early ones, your more refined ones, you've got to have time to make sure that you have given every effort to creating the best arguments for your client possible. So with that in mind, it starts with making sure you have enough time. I know that the practice of law can be incredibly busy. I know how difficult it can be to juggle practicing law and personal life and juggle 15 cases and billable hour requirements and dance recitals and doctor's appointments and everything else in between, right? It's not an easy thing to do. But what you do need to do is be sure you have the time to put forth the best work product at the appellate brief writing stage. So take that deadline you put on your calendar, right? Way back there early in these commandments, you had a calendar, you calendared your deadline. Back it up from there. If you're going to have enough time to effectively edit and proofread your brief, when do you need to have a first draft done? When do you need to have a second draft done? Are you a solo practitioner and you're the one that has the final say? Or are you the partner? You're the one that has the final say? Okay, then keep that in mind. But if you're an associate or you're working with other attorneys that are going to review your work product before it goes out the door, keep that review process in mind too, right? So if it's due on the 3rd, when do you need to have it to the partner for them to be able to review it and back to you? And before that, when do you need to have it drafted so that you can do your initial edits and your initial proofreading before it moves on to the next stage? I mean, there are always exceptions to every rule, right? And I said nothing here that I'm saying today should be taken as this gospel God-given truth that can't be changed or varied in any way, shape, or form. But as a rule of thumb, you're not going to effectively write an appellate brief in a few hours. And in most cases, you're not going to effectively write an appellate brief even in just a few days, right? You're going to need time for it to be a living, breathing kind of document. To the extent practical by your deadlines, you are going to need time to revisit it. And your other cases don't stop just because you have one that's involved in the appellate process, unless you specialize in appeals. And even then, you probably don't have just one case, along the way. you're working through multiple appeals. So you've got to make sure you've got time to deal with those other matters, to step away from your draft, and then revisit it. I say this all the time about my work product in various circumstances, that I'm going to revisit it with fresh eyes. And that means that when I've been looking at my computer screen for hours on end, I am not at my peak game, right? Something I wrote at 6 p.m. or 10 p.m. or 3 p.m. even may not be the same product that I would have written at 9 a.m., right? And so I'd say that I need all versions of me to be able to look at my product and determine that it's effective. And so for me, once I've cranked out a draft, I might read through it that night, but I also like to give myself enough time to step away and say that draft is done. And whether it's go work on something else because it's early in the day, whether it's sleep on it for the night, which is personally my favorite way to get fresh eyes, come back to it again and see it in a whole new light. I will say, I would bet every penny I have that every time I do that, I see something, right? It is rare that I come back to my first draft with fresh eyes and say, yeah, I just missed a period there. I rephrase how I say sentences. I find new typos that I didn't catch the night before, even though I read it 15 times, right? But my brain is inserting it. It's saying that's what I wanted it to say. And when I come back the next morning, I'm like, that doesn't say what I thought it said. So you need time to step away and do that. And you want to be able to do that more than once, ideally, right? Like you want to have time to write a brief and finish that brief and then step away, come back, edit it, step away, come back until you're in a place that's comfortable where you're not seeing those, glaring issues anymore, or where you say, yes, you know what? I have fully captured the argument and things make sense here. At the end of the day, like you want your work product and your appellate brief to be something that you can say, I'm proud of this, right? That at the end of the day, you're like, yes, I am pleased with this product. I would be happy to turn it over to anybody. If I was interviewing for a job, this would be a sample I would love to submit if I could. If it got published on the front page of the New York Times, I'd be glad my name is attached to it, right? That's the kind of work product you're striving for. And you don't want to submit a typo to court. I think that anybody who's ever submitted something with a typo in it to the court knows that when you see it later and you see that typo and it's too late, it's just staring at you. And while other people might not be thinking about it that way, for you, it's like something you think about every time you look at that document. I remember once I had a caption, right? It wasn't even the body of my brief, but it was a caption where I had transposed 2 letters in district. And this was a trial court filing, but I saw that and I wondered how long that had been there, right? Because I don't change the caption every time. And now I spared myself the expense of going back through the docket and checking everything that I'd ever filed. But those little things, once you see them, you can't unsee them. And you don't want to have that if you can help it. Even when you think that you've read it enough, read it again, read it one more time. And then I personally am also a big fan of, after going through this editing and proofreading process, that when it gets to, submission date, I like to skim through things again before I submit them to the court. And that way I can just say, yes, I see all of the things that I needed to see. This all makes sense. If you were editing with someone else, that you got all the red lines, right? There's not something weird and wonky in there from that editing and proofreading process. And if you have the ability to ask someone else to read your work product before you submit it, then by all means, please do, right? If you've got a partner, if you've got other associates, if you are not a solo practitioner, or if you are, you have a paralegal, right? Someone else to be that set of fresh eyes and just say, read through this. Because oftentimes their fresh eyes will catch something that you didn't see because you're the one who wrote it. And in your head, you've said what you wanted it to say. And be sure you use whatever tools and resources that are available to you, right? And this is not something I'm going to dive into on the, confidentiality and the ethics, portion of things to check into whether or not your tools are secure. And that's definitely something that you should be keeping in mind, and something that you can, discuss with your team and look at the rules in your jurisdiction and what makes you comfortable and what makes you not. But there are tools out there to help you with this process. Things like Grammarly, I personally like for various types of writing, even in my personal life. Just to kind of give me an update, Microsoft Word, right, has the built-in spell check tool. Click the button. You would be surprised, right, how often people forget to double check that or to let it run spelling and grammar check. There are other more sophisticated tools out there that you can, run your briefs through, and it'll supposedly check for things like overturned case law. I don't personally use those consistently, but they're available on the market, right? I guess the point that I'm making here is whatever tools are at your disposal that you are comfortable using that will make your writing better, by all means, use them. And it will help you turn out a better product, something that's more effective for your client and is better received by the court. And then in this proofreading process, if you didn't catch it last time, I didn't say it enough, don't forget to proofread your citations. And that's part of the checking your citations phase of things. But when you accidentally hit, 348 Southern Second instead of 248 Southern Second, it's going to pull a completely different case. And you don't want to have to send the court or your opposing counsel or anyone else hunting for the case that you meant to cite. And then number 9 here is remembering your role in the appeal, right? Thou shalt remember your role in this appeal. Are you the appellate or are you the appellee, right? That's a very basic standard, but it's something that, you need to keep in mind along the process because it's going to answer questions like, is the standard of review favorable to you, right? Is it favorable to your position? Are you going to have a second opportunity to address your opponent's arguments, right? Are you going to get to submit a reply brief, or is it a one and done shot for you? Are there different sections required in your brief as opposed to your opponent? So for instance, sometimes it might be the statement of the facts, or it might be the issues presented, where the appellant has to submit those things, but the appellee does not necessarily have to do so unless they disagree with what the appellant has said, or they want it to be different what has been submitted to the court by the, other party. They don't want to accept that before the court for the purposes of this appeal. It may be that you don't have to include everything, and that may also vary depending on your jurisdiction. So knowing your role in the appeals process influences everything in this, right? It influences how you frame your arguments. It influences the arguments you may or may not raise. Sometimes there may be a reason to reserve an argument for reply. Or it might be that you can only address points made in your, opponent's brief. In which case, if that's the standard that you're working under at your level of appeal, and it often is, then, you want to make sure you confine yourself to those points. But you need to know what your role is so that you can ensure you're kind of coloring within those lines and doing the best things possible for your client in that regard. And then that will bring us to the 10th commandment. Thou shalt develop your style. If there is anything that you have learned, over the past 50 minutes of listening to me talk to you about this presentation and talk to you about appellate brief writing, it's that you will have what works for you. And so I can talk your ear off about, what works for me and how I approach appeals and how I approach drafting and how I approach the entire appellate process. But that might not be what works for you. You might not want a 3-year paper calendar with all of your deadlines in it. You might do just fine living and dying by Outlook or living and dying by Clio or your Google Calendar or whatever it may be, right? And that is awesome if that works for you. But for me, it's the calendar. You will also learn from everybody along the way, right? So as I sit here and I, talk at you for 50 minutes about how I write appellate briefs, you're going to work with other lawyers, both, in your own office and your own colleagues, as well as other lawyers and opposing counsel who will help develop your style too. You'll see what other people do in their briefs that you like. You'll see what other people do in their briefs that you don't like. And you'll see that, things that you can change and tweak about your own style based on what you've seen in their style. Because people will say all the time, Rome wasn't built in a day, and neither is an appellate writer. So as I sit here before you about, giving this presentation, the truth is that in, a year, I could give another CLE about this topic, and my advice might vary. I might have discovered a new way of doing things. I would have learned something. I would have, had another experience. And so I think that's something to remember too along the way, that you are still learning and growing and developing, whether that means you're a first-year associate, whether that means that you are, a 50-year-old partner or a 60-year-old partner or somebody who's been practicing for 50 years. And you'll still develop your style every day as you kind of take in and learn and grow about what's effective and what isn't. So with that in mind, you have to be prepared for a couple of other things, right? You'll know how to develop your style and you'll continue to grow, but you have to remember that, especially if you're early in the process, but at any stage, accept feedback in stride, right? You don't want feedback to get you down. It is rarely a personal criticism. I don't think I've ever worked with anyone that I thought was trying to criticize me personally. I think they often just want to help you improve and help make sure that you're doing the best job possible for your clients. So kind of keeping that attitude in mind and being ready to just accept all feedback in stride is fantastic. The other thing to remember in that is not to be discouraged by red lines. One of the steps here I said was whether you're, working with someone else on the case or just working with others in your office or your paralegal or whoever it may be. When someone else reviews your work product, they're going to have feedback. Don't be discouraged by red lines in your appellate briefs. And I say that to say, I know I'm someone, when I proofread or when I review written products, anybody who has worked with me and asked me to proofread something can say, I very rarely send it back with no edit or no comment whatsoever. And that is something that is just because I have a style or I have thoughts or I have opinions. And sometimes there are things that have to change, right? Sometimes they are errors, but oftentimes it's also a presentation of how I interpret something or how I would frame something. And so you've got to, in the feedback and review process, kind of be able to distinguish between those two, right? To be able to distinguish between what is, feedback that needs changing absolutely, unquestionably, because it was a typo or because it was wrong or because it was incorrect, and what is feedback that is more stylistic or feedback that is more about the process or what somebody prefers. And I can say this too, that even if you're an associate attorney or earlier in your career and you're in that phase where even when it comes to stylistic choices, you have to accept the way someone else wishes to do it, it's still good to see that feedback and know, as you develop your own personal style, kind of what sticks for you and what lands for you and what does not, right? And I think too, if you're in the right environment, it's an awesome opportunity when you have something like red lines to discuss it. I work in a small firm with some fantastic attorneys, shout out to them. I love them all immensely. But there are times where I can say to, one of the partners that I work with, hey, I disagree with this comment because, or I think that this would, make more sense this way because, or where I can say, what are your thoughts on this? Or could you give me some more insight into why you suggested this? And I think those are great opportunities to kind of grow and develop your style too. So that, when all is said and done and push comes to shove, you're all better writers and you're all better attorneys for it. So with that in mind, I think that's the end of my presentation because I don't remember anything else I wanted to say to you and my slides aren't going. So I'd be happy to take questions at this point if there are any.
Awesome. Thank you so much, Marina, for your presentation and highlighting some core principles that can help make appellate writing the best it can be. As Marina mentioned, we can now go ahead and take any audience questions. So if you have any questions for Marina, please feel free to submit them by clicking into that Q&A button in the control panel at the bottom of your screen. It looks like we already have a few, so we can go ahead and dive right in. Let's see. Our first question is, what are some best practices for creating a thorough outline that flows logically and keeps the reader engaged?
Yeah. So I think the thing to remember with your outline is kind of best practice wise. I think that there are tons of resources out there, right? If you want to go back to, your 5th grade English class, right? We talked about the Roman numerals and, your topic headings and kind of the things that go within that. I'm a bullet point kind of girly. And I say that because I will go through and I will type out a heading or an argument or a point I want to make and kind of feed under that different things that go into it. And if I'm doing it on pen and paper, I'm a crosser outer to reorganize. I think something to remember about your outline, at least while you're developing it, is it's living and breathing, right? Like this is not your brief itself. So when you get there and you're like, I don't like section 3 here, it should be above section 1, or it should be after section 5 or wherever. You can do that. You can rearrange it and you can decide, okay, I've gotten there. And then the flow through it, I think that's often an instinctive thing, but have you kind of set the stage and told the story that you're looking for so that the next point kind of leads, you've got that beginning, that explanation, and that end before you move on to your next point. What you don't want to do is not close the loop on something before you've answered the question that you were trying to answer, right? You want to make sure that you definitely close that loop first before you move on to a point so that nothing is still open-ended. And so that would kind of be a thought I have, there on kind of organizing your outline and going through it. But if that doesn't answer your question, by all means, let me know.
Thanks, Marina. Our next question is, do you have any advice on drawing a line between criticizing opposing counsel's legal arguments without inadvertently making the argument feel personal?
Yeah, no, of course. I think it often, can inadvertently feel that way, right? And that's definitely not the intent. I am a big focus on, stick to the argument itself, right? I try to avoid, and I'm not going to say I'm perfect at this, but I don't use the word language, if I can help it, opposing counsel in my brief, or counsel for the appellant, or counsel for the plaintiff, right? Because at the end of the day, I try to think of them as out of this, right? And so I'll say the appellant, right? Because it's their argument, right? And say things like appellant suggests, or appellant contends. And that kind of helps keep it a little bit more, I think, for me, anonymous, right? And less of a personal attack. I do like the language focused on arguments, right? Like to the extent that it's fair to say appellant argues, because then it's a focus again on their argument or what they've put before the court, and less so about, them as a person.
Awesome. Thank you for those tips. Our next question is, how can I efficiently keep track of differing local rules across multiple jurisdictions, especially when it comes to formatting my briefs?
Yeah. So I am a one jurisdiction practitioner, for a better way to put it, right? I'm licensed in Louisiana. If I do something, it's in Louisiana State Court or federal court. So I think that's a really great question. If you are working in lots of jurisdictions or you've got multiple jurisdictions, I would suggest really just creating a, checklist for all of them. And I say that to say, I don't necessarily keep a written checklist at all times. That's something that I will often do at the beginning of like each new brief, right? And now there are some things that I can, borrow every time, right? But, double checking and going back through and saying, yes, okay, I've got, the answer to this question here. I've got my facts here. I've got this here. Okay, here's my new outline for this brief for this case. So I would suggest maybe to kind of help streamline that for you, go ahead and make a checklist for all the jurisdictions that you're practicing in. Keep it as like a shell, and then just make sure you're updating it and double checking those requirements are still accurate kind of at the outset of a brief. And then that way you can know, like, okay, in Alabama, you need to do these things. Here's my Alabama checklist. Double check. Yep, that's what the rules still say. Get to writing.
Awesome. Thank you. Our next question is, when I'm addressing both favorable and unfavorable facts, how can I balance honesty and advocacy without undermining my client's position?
That is another tough one. I think that, in every circumstance, right? Like I very rarely have a case where everything is favorable or everything is unfavorable. Honesty, the duty of candor to the court, right? We all learn about that in our ethics presentations and classes in law school, rule number 1. So honesty kind of does come above, I hate to say all else, but all else, in the sense that, you cannot lie to the court. You just can't. That being said, I think, there is definitely a balance between saying, my client was wrong and instead saying, what my client did. And then I honestly find like if you've got a lot of unfavorable facts, hopefully the law is in your favor, especially when you're at this stage, right? That, you've been through something that is like, yes, but the law says this. And so, really you've got to kind of develop that art of focusing on which portion of things is more favorable to your client. Is it the facts? Is it the law? And leaning into that as much as possible. And it could be both. But just making sure that you're not, like I said, lying about anything because you can't be dishonest.
Awesome. Thanks, Marina. Our next question is, do you have any tips for organizing record and legal citations so that they're easy to access and verify when you're editing?
Yeah. So a couple things I'll do is I like to spend some time with the record before I start really writing. And kind of going through, I would say this is probably part of my outline phase. In that, I know these are the arguments I want to make, these are the things I want to say. And then I can go through in that phase and say, okay, where is the fact to support this? I personally find that if you've been involved with the case a long time, it gets a little bit easier because like, oh yeah, it was when we were at the summary judgment stage, they said this. And so you can go back through and kind of find that. But even if you haven't, taking time to familiarize yourself with the record is helpful. And then that way you kind of have a rough idea, like, okay, these are my facts that are important to me. I personally, when I'm double checking record sites and I'm double checking my citations to like the law and things, I split my computer screen in two. And so I will put like whatever it is, my, brief on this side, and then where I'm checking on this side so that I can, kind of line by line and say, okay, here's my first citation. Then I've got, my research tool pulled up over here and I'm dropping that in there, search. Okay, that got me the case I needed to. And then the same thing for record sites, right? Like I've pulled up my record on this side. Don't worry, I pull those PDFs and things off of the CD so I don't have to use the CD the whole time. And then I'll be sitting there like, okay, so this said record page 5. On record page 5, yep, that's what I referenced. And then that way I can go through it systematically like that. So for me, a separate list is less helpful than looking at my final document.
Awesome. Thanks, Marina. Our next question is, how often should I recheck case law or factual assertions to avoid potential misstatements, especially when I'm drafting multiple briefs in a short time period?
Yeah, I mean, I think something to, temper everything with realism, because, they would say every single time, and I do tend to be in that camp that I am the person that I said in my last step before I submit something is double checking all those things. Thank God I haven't been in a situation where, I run a citation right before I submit something and discover my whole case law has been overturned. That would be definitely unfortunate. It would probably result in a very late night for me. But I do at minimum do it before it gets submitted, right? So as I'm drafting, I'm popping things into, research tools and making sure they're correct still. And then before I submit to the court, one of the last things in my finalizing my brief process before a signature goes on it and it gets uploaded is making sure that my citations are accurate, that that is still a good case, and all of those things.
Awesome. Well, thank you so much. That's all the questions we have time for today. So thanks for your additional insight, Marina, and thank you all for your wonderful questions. We want to thank you for joining us for another Justia webinar. Additionally, as I mentioned at the top of today's presentation, in the spirit of staying up to date with the latest developments in the courts, we wanted to remind you of that great free law resource that you have access to as a Justia Connect member, the Justia Daily Opinion Summaries. By signing up, you get free next day alerts summarizing opinions of the courts for the practice areas and jurisdictions that matter the most to you. You can sign up for free at newsletters.justia.com to stay in the loop about what's happening in your practice area and jurisdictions. And have a wonderful rest of your day. Thank you all. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next clip.